Thanks for making it to Veterans Info Tap. I'm glad you made it. Today I wanted to talk to you about some interesting twists with regard to the settlement of $6 billion for the hearing loss and hearing injuries that were incurred due to the 3M earplugs. Now, what I wanted to share with you is this article that I found, and it's all in the headline here, and I want to go ahead and read it to you. This just came out a couple days ago. And the headline here is 3M judge issues extraordinary order to shut down predatory litigation funding. So another twist in this lawsuit and litigation settlement and all that good stuff. So wanted to share it with you. Please hit the thumbs up, subscribe, share with a friend, all that good stuff. I really appreciate it. It helps the channel and helps to get this information pushed out to those that need it. So this, again, just came out September 5th. The federal judge overseeing the proposed $6 billion settlement. Now remember that the $6 billion settlement must be accepted by 98% of the veterans involved in this mass tort litigation. So keep that in mind. This is just a proposed settlement at this point. It has not been fully accepted yet. Settlement of claims against 3M by hundreds of thousands of U.S. Military veterans and service members is apparently not a fan of litigation funding. In an extraordinary order last week, U.S. District Judge Casey Rodgers, Pensacola, of the Pensacola, this thing's flopping around on me, of Pensacola, Florida, ruled that plaintiffs' lawyers with cases in the 3M multi-district litigation may not approve or participate in any deal between their clients and outside funders offering high-interest cash advances in anticipation of payouts from the proposed settlement. The judge also barred claimants in the multi-district litigation from entering any deal with a litigation funder without obtaining her approval in advance. Rodgers, that's the judge, said she wants to be sure that plaintiffs in the consolidated litigation, which involves claims that 3M military-issued earplugs caused hearing loss, are not exploited by predatory litigation funders who charge exorbitant fees and rates of interest. Like I said, not a litigation finance fan. She appears to be the first multi-district litigation judge to place significant logistic obstacles in the way of post-settlement agreements between plaintiffs and lenders offering them advances on their settlement money. According to several litigation funding experts I consulted, like many other federal courts, Rodgers also called for the disclosure of pre-settlement litigation funding deals, citing her authority under the federal rules of civil procedure. But the experts I spoke with could not recall a previous case in which a multi-district litigation judge flat out barred plaintiffs' lawyers from facilitating a funding deal for their clients and prohibited claimants from entering a deal without court approval. It's a significant leap, said Jack Kelly, managing director of the American Legal Finance Association, a trade group for funding companies that offer non-recourse advances to plaintiffs. Charles agreed of Westfleet Advisors, which issues an annual report on the litigation finance market, said Rodgers' order is unique, adding, I worry about the ambiguity. Oh, God, that's horrible. And whatever. You know what I'm trying to say. Sometimes I feel like Porky Pig. All right. Surrounding the standards by which the court would approve any such new transactions, or worse, potentially invalidate or void any historical agreements. Rodgers, who did not say what prompted her order, certainly has reason for concern about lenders who contend that double-digit interest rates are justified by the risk that is proposed, that a proposed settlement will take years to win approval or won't be approved at all. Plaintiffs Let's see here. Plaintiffs who take advances against their anticipated settlement payouts, often because they need quick cash to pay bills or medical expenses, don't have to pay anything back if they don't recover any money. Rodgers cited a December 2022 study from the U.S. Government Accountability Office, which noted that post-settlement funding deals can create conflicts between plaintiffs and their lawyers and can gum up settlement approval when plaintiffs seek extra money to pay back litigation funders. A law professor from the University of Texas who has co-authored landmark litigation funding studies told me by email that he is sympathetic to Rodgers' apparent goal of restricting these deals in the earplug multi-district litigation because funders in the past have sought crazy interest rates when they've advanced money to plaintiffs expecting payouts from settled cases. But Rodgers' order, however well-intended, raises two important and related questions. Will the restrictions actually deter funders, and does the judge have the power to block plaintiffs from entering into private contracts with litigation funders? Good question. You may recall that in previous multi-district litigations brought by retired NFL players who blamed the league for their neurological injuries, U.S. District Judge Anita Brody in Philadelphia was so disturbed by allegedly exploitive funding deals that she tried after the fact to invalidate agreements between litigation finance companies and retired players. Funders challenged Brody's wholesale invalidation of their contracts in 2019 in a landmark decision on the scope of the court's authority, and the Third U.S. Circuit Court of Appeals ruled that because the player's settlement with the NFL contained an anti-assignment provision, Brody was within her rights to strike down funding deals in which players assigned their claims to outside funders. But the appeals court in the NFL case held that the multi-district litigation judge did not have the power to stop funders from bringing actions to demand repayment after players received their settlement money. Brody's authority, the appeals court said, ended at the border of the multi-district litigation. She was not entitled to void contractual provisions that went only to lenders' rights to receive funds after the players acquired them. Rodgers, perhaps mindful of the Third Circuit's admittedly non-binding analysis of the limits of her authority, did not entirely preclude earplug plaintiffs from contracting with funders. She said instead that they must obtain her approval to enter the deal. So can plaintiffs sidestep the order, claiming that the multi-district litigation judge can't bar them from entering a contract outside the scope of the multi-district litigation. And what happens if a plaintiff in the earplug case does make a funding deal without Rodgers' approval? Litigation funding expert Anthony Seebach of the Benjamin R. Cardoza School of Law said multi-district litigation judges' only recourse might be to dismiss the plaintiff's case, a harsh penalty for the claimants Rodgers wants to protect. Rodgers does have the power over the plaintiff's lawyers in the multi-district litigation and barring them from facilitating funding deals, which typically include a letter in which the plaintiff's lawyers promise to pay the funders from the client's proceeds, could chill agreements. But Peter Buckley of Fox Rothschild, who represents a litigation funder from the NFL case, said funders can structure agreements to work around that part of Rodgers' order. In fact, Buckley said Rodgers' order could turn out to be a boon, could be a boon for good faith funders, as long as the judge gives fair consideration to proposed deals. His reasoning: advance court approvals of funders' repayment process will reduce the risk of plaintiffs trying to evade contractual obligations after they receive settlement money. My client would welcome that, Buckley said. But would Rodgers approve any deal a funder would consider to be financially viable? That's one of the many open questions arising from the order. I suspect we haven't heard the last of the issue. A 3M spokesperson declined to comment on the litigation funding order. Plaintiffs co-chair Christopher Seeger of Seeger Weiss was not available for comment. And then there's some more information on a couple different hyperlinks here, but just wanted to bring you up to speed on that. So a lot of times when you have money that's coming to you or owed to you, you can go to these funders and they will basically give you money up front, again for a steep fee. But for some people that are in desperate need, it is maybe the only option that they have is to basically put a lien on their future settlement money. And is it right? Is it wrong? I personally think that it's an individual choice, but it does sound like the focus is on the lawyers facilitating the deals, and that the plaintiffs themselves can actually still facilitate a deal with one of those funders if needed. Thanks for watching. I appreciate you. Have a great one, and remember, if we don't take care of each other, something went wrong.